So Jonathan is Jonathan Kavner, CCH, discovered homeopathy in 2010 and has since devoted his life to Hahnemannian homeopathy, following in the footsteps of his professor, George Vitulkis. Working from a classical perspective, Jonathan believes in the innate intelligence of human beings to move in the direction of health while protecting themselves from damage. By tapping into this intelligence, homeopaths are able to provide an effective stimulation to shift the body back into balance. So really great way to put what we do as homeopaths. And so Jonathan, we're excited that you're here and we're excited to hear about PMAs. So go ahead and get started.
Thank you. So as all of you know, there are a variety of different ways that we're able to operate a practice and offer our services. We can provide our services under a physician's license because a physician has permission from the public authorities to prescribe drugs. And they receive this permission in the form of a license, specifically a medical license. A license means permission to do that which would otherwise be considered to be illegal by the public authorities. So prescribing drugs to members of the public is something that is restricted to medical physicians with the medical license permission to do that. So we can practice under a physician's license. We can also operate through a limited liability corporation, an LLC. But when we do that, we need to be very careful about the language that we use. We need to be very careful about what we say and how we say it. And the reason why we have to be careful is because an LLC is a creature of the state. The state creates the LLC and makes it available to us so that we can provide services to members of the public, which the public authorities are responsible for protecting. So again, along those lines of the medical license, the public authorities are creating the LLC for us to provide a service to members of the public, but we're not allowed to heal or treat or cure or prescribe because all of those things are limited to the medical license. So what we do when we operate through an LLC is we have them write, sign off on liability waivers and different types of claims, in which, we're not practicing medicine and we're not prescribing anything and we're not healing anything, we're not curing anything. And then we have to be careful about how we actually speak. We can't call them patients, we have to call. We can't say that we prescribe, we recommend. All of these things, if you think about it, are restrictions and limitations on our freedom of speech. And our freedom of speech is a fundamental right that was granted to us by our creator. So here we are trying to kind of have a foot in either world, right? We're trying to kind of walk a tightrope and provide this service to the public, but we can't really provide it the way that, well, at least the way that Hahnemann would have wanted us to be prescribing it. Because if you think about it, from the first aphorism of the Organon of Medicine, the highest calling of the physician is to eliminate the suffering in the individual, otherwise known as to cure. But you can't use the word cure, even though, frankly, that's what we're doing. So here we are having to compromise our fundamental freedom of speech in order to practice our trade. And that's where a private membership association comes into play, because with a private membership association, there are no services being provided to members of the public. Services that are provided through a private membership association are being provided exclusively to members. So the public authorities who are there and responsible for protecting members of the public no longer have the jurisdiction over the private contractual relationship that's taking place between members of a private membership association. That in order to provide that kind of service, though, through a PMA, we need to have an explicit agreement in place And that's the reason why private membership associations need to be properly formed. They need to be written in such a way to keep the terms of that agreement outside of the public authority's jurisdiction, outside of their venues for addressing disputes. And a properly formed private membership association exists entirely in what's known as the private domain. The Supreme Court on many occasions has affirmed the existence of the private domain separate from the public domain. And in the private domain, that's where our fundamental rights exist. Our right to contract, our freedom of speech, all of those things exist in the private domain, but in the public domain, they're limited. They're limited in the sense that, like, for example, in other words, you can't scream fire in a crowded theater. Now, for good reason, but at the end of the day, that is a limitation on your freedom of speech, and for good reason. I'm not saying that it's not, but it is a limitation on your freedom of speech. Now, you could say that in your private home, and no one's really going to be able to say anything about that because it's in your private home and it's in your private space. Another good example I can give you is in regards to a medical physician again. Now, when you're granted permission from the state to provide, medical services to members of the public, there are limitations that come with that permission. The license is limited. You cannot advocate for any sort of treatment or modality that is outside of the standard of care. So again, a medical physician is limited in what they can say when they're providing a service to members of the public, because the public authorities which granted them permission to do that say, listen, you can advocate for modalities and treatments that are within the standard of care, but nothing outside of that standard of care. So here we are censoring their freedom of speech in exchange for the permission to provide the service to the public. Now, if that physician with a license wasn't acting as a licensed physician treating the public, but was instead Jim or Larry at my home, at my dining room table, having a conversation, he could say whatever he wanted. He has the freedom of speech. And in that private setting of the private domain, his license isn't how he's operating. So he's able to say whatever he wants. A private membership association is kind of like that. It's kind of like your family. There isn't any sort of limitation on your freedom of speech. The only limitation on your right to contract and what your fundamental rights in regards to providing services to people in the private domain is that there cannot be any clear and present danger of substantive evil. So you have almost the unlimited right to contract in this country. And I think it was 1905, the Supreme Court case Hale versus Henkel, which described the private domain versus the public domain. They stated that a private individual's right to contract is unlimited, and that's what they said in their decision. Since then, there has been a little bit of a limitation on one's right to contract, and that is when the Supreme Court put into place what's known as the clear and present danger doctrine. This is a legal test where if there is a clear and present danger of substantive evil with malicious intent, then there's no contract that's no longer going to be valid. So suicide pacts, murder for hire, things like that aren't valid contracts because there is that clear and present danger. So, when operating through a private membership association, and here we've got a contract with members to provide services, and members are agreeing to hold harmless, waive liability, not commence in any sort of investigation or action against any other member of the association, the only limit to that would be is if there was a clear and present danger of substantive evil, which is one of the reasons why I always suggest when operating through a private membership association is that you still remind people that if they have any health concerns, that they can speak to a licensed physician, just so that people know that that's something that's still on the table for them, to eliminate that clear and present danger that would exist had they not been aware that that was something that was still an option. So private membership associations allow us to provide our services not to members of the public, but people who have consented voluntarily to the agreement to become a member of our association, whereby we can then provide services to them as private members. And this allows us to say what we need to say. We can use whatever language we like, because when people are consenting to the agreement, they're recognizing that they are capable of making this decision on their own behalf, that they are it's up to them to choose who they take wise counsel from, that they understand that the members of the association that may be providing service to them may or may not be licensed professionals, and that they understand this and hold harmless and waive liability and agree not to participate in any sort of investigation or commence any action against any other member. That's the bulk of a private membership association in regards to the protections that it provides, in that it operates in the private domain instead of the public domain, which is the domain of the public authorities who have the responsibility to protect members of the public. And therefore, anybody providing services to members of the public have to abide by the rules and regulations that exist in that public domain. So this is one of the reasons why private membership associations are helpful to homeopaths, because if you think about it, what is it that we do? The FDA says that, what we're prescribing are drugs. I mean, that's how they categorize homeopathic remedies, is they prescribe them, they're categorized as drugs, over-the-counter medications. And here we are recommending, prescribing drugs to people without a license, unless we're in one of those 3 states in which you're going to be a physician anyway, and therefore you can prescribe whatever you like. So here we are, unlicensed practitioners who are prescribing drugs to individuals. It's clearly an exposure for claims of practicing unlicensed medicine. But if we don't provide any services to members of the public, and instead we only provide these services to people who we have a private contractual relationship with, the government cannot intercede between parties of a private agreement. So we're able to practice our trade through a private membership association without that kind of concern for us as unlicensed practitioners. And that's one of the benefits and one of the protections that exist in having a private membership association and operating your practice through it. Now, I still maintain professional liability insurance, even though my members, agree to waive liability, hold harmless. I still feel it's prudent to do so. And our liability insurance that we're able to obtain through the Council for Homeopathic Certification's relationship with, I believe it's Huntington, which is an insurance carrier, insurance broker, provides protections for us as trustees of associations, and provides us with liability insurance should we provide homeopathic services, even to members of the public. So it's kind of like almost like a belt and suspenders, in which we're having an extra added layer of protection, in operating our private membership association. I've been operating as a private membership association for a few years, and I've worked with people who have been providing their services through private membership associations for decades. I know a lot of chiropractors have been doing this, because chiropractors typically like to play with all sorts of new toys, and a lot of those new toys wind up being outside of the standard of care or the scope of their practice under their license. and therefore they've historically used private membership associations in order to continue working. I've lectured and I've given workshops and I've given talks to a number of different groups, including homeopaths. And I know of many that have established themselves as private membership associations. And frankly, it's not just homeopaths. I can tell you that there are at least two large homeopathic pharmacies and distributors in this country that are set up as private membership associations, in which the remedies that they sell are not available to the public. In order to purchase a remedy through either of these two organizations, you have to consent to the membership agreement and be a member in order to be able to purchase homeopathic medicines from them. And if you think about it, over the past couple of years, there have been a lot of limitations on life in the public domain for people who may or may not have had certain medical interventions or met certain requirements. And frankly, that's a little bit concerning when we talk about overreach of the government in regards to what our rights are. People can't go to certain places unless they have certain identification or if they've done certain things. But those things don't necessarily exist when we're operating in the private domain. So over the past couple of years, you've seen an explosion in the private domain where all sorts of different businesses are providing services through private membership associations. And what we have now in this country and all over the world actually is a network of private members that provide their services not to the public, but to people who have consented voluntarily to become members of the association. And therefore, that's how they're able to access those products and services outside of the regulations of the public authorities. So regardless of whatever mandates or restrictions or limitations that the public authorities may impose on doing business in the public domain, they don't exist within people who have private contractual relationships between one another, such as those through a private membership association. So this is kind of why homeopaths and others use private membership associations to provide their services. And it's something that I think that everyone who is a professional should consider in regards to providing a protective envelope for what it is that they do, lest they run the risk of being, accused of practicing unlicensed medicine. Should they use the wrong language? Should they say that this will heal you, or that they are prescribing this or that, or they're suggesting that somebody might be their patient? And that's one of the reasons why I think that, more and more people are moving towards private membership associations. And I would highly recommend that for everyone here who's a practitioner to consider that as well. So thank you very much for being given the opportunity. I know that was a long 20 minutes. Surprisingly, I actually can breathe while I talk. But I would love the opportunity to kind of talk with people and answer some questions. I've seen a couple of questions pop up in the chat along the way, so I did want to, kind of answer some of those. Catherine had a couple, whether or not this was directed at practitioners who live in states that do not have safe harbor laws. There's only a handful of those states that have safe harbor laws, but again, those safe harbor laws are still in regards to providing services to members of the public. And while they are helpful, they are still something that the government is what is regulating. So while some people might feel very, very comfortable, operating within the protective envelope that the government provides in regards to individuals, there are a lot of us who don't necessarily trust them so much when it comes to what it is that we do. And therefore, it sometimes makes a little bit more sense, even in safe harbor states, to limit your practice to people that you have a private contractual relationship with. when Rena had asked, well, where do you start with setting up a PMA? It starts with the documents, frankly. You could go to your local attorney who's a member of the Bar Association, who is an officer of the court and is, has sworn an oath to practice public law, and they'll charge you a ton of money to create a document that is a private membership association. But don't be surprised when the venue and jurisdiction clause of that agreement finds that the venue for that contract is in the public courts of the local county or the state, because that's the limitation that attorneys, licensed attorneys, members of the Bar Association have, in that they're not able to draft a non-statutory agreement. As George Carlin said, it's all a big club and you're not a member. They're all part of the same organization. So if you're an attorney and you have a license and you're a member of the bar, you have to write a statutorily compliant contract, which keeps the terms of that contract and any disputes within that agreement in the public courts. So when you're starting to look to have language drafted for a private membership association, you're going to look for people who specialize in non-statutory agreements for private membership associations. I'm one of them, and there are a number of colleagues of mine that also work in providing private membership association documents for practitioners. I've worked with physicians. I've worked with medical doctors. There are a lot of medical doctors out there that are looking to do all sorts of wild and crazy things with stem cells and all sorts of stuff. But they're not allowed to because of their license. So they've come to me in a lot of circumstances to have documents drafted for private membership associations so that they're able to provide these alternative modalities without running the risk of jeopardizing their license. I've worked with chiropractors and homeopaths and naturopaths and acupuncturists, especially practitioners who, had questions about their ability to renew their licenses in the past couple of years because of new requirements that certain states were imposing upon, for example, chiropractors who wanted to renew their licenses. And there were certain things that licensed chiropractors were not willing to do, even though the state was mandating that it be done in order to renew their license. Yet they still had 40 or 50 years of experience as a chiropractor and wanted to still practice. So, they've been working on establishing private membership associations to help people for that as well. So, there are a number of organizations that are out there that provide private membership association documents. And that's kind of probably the first place to get started on that. Obviously anyone is free to reach out to me, and I'd be happy to kind of to help and explain and even provide documents for people who are interested in taking that forward. David asked a question about what do I mean by non-statutory agreements, and I mentioned this briefly. So a non-statutory agreement is, so a statutory agreement means that something is statutorily compliant. It means that it complies with public law. There's, taking a step back for a moment, law, L-A-W, land, air, water. So water, maritime law. Maritime law is the law of codes and statutes and rules, regulations, and licenses. Maritime law is what we typically are exposed to when we think of law. And, all documents are going to be, for the most part, written in this type of law, okay? Maritime law. And it puts certain limitations on where disputes can be arbitrated and what the parameters are for an agreement to take place. A statutorily compliant contract would have a venue and jurisdiction clause, which states that any disputes related to the terms of this agreement must be arbitrated through the courts of the state of whichever state, you know, the document was written in. And the problem with that is, in regards to a PMA, is that it essentially puts the terms of the agreement that people are consenting to keep their business private, decided by a third party who is a public, you know, official, who is, you know, within the public domain and within that jurisdiction. A non-statutory document does not have that as a venue and jurisdiction. Law, L-A-W, land, air, water. Land, the law of the land is common law. Common law doesn't have all of these rules and regulations and mandates and licenses and all sorts of things. Common law is actually really simple. Don't take what's not yours. Don't hurt anybody, and be genuine in your contracts. That's common law. And in common law, we can consent to contracts, sometimes also known as contract law. We can consent to terms of a contract as long as we are being genuine and sincere in our agreements that we are consenting to. And that is common law, or the law of the land. Air, the law of air, is ecclesiastical law. That's the law of people who have faith. It's the law of belief. It's spiritual law. It's where religions get the authority to impose their rules and regulations regarding to what people believe who are members of a certain religion, or people who have faith. So these are the different kinds of law that are there. And you kind of have to know where it is that your agreement is being written in. And we don't want our agreements written in maritime law, because then we're subject to those public rules and regulations that govern maritime law, you know, that work within maritime law. Instead, we want our contracts to be written in common law. So when I create private membership associations, I'm doing that in common law. And that's what people are consenting to, is a common law contract. I'll give you a little example of licenses and law. Remember what I said about licenses? I said licenses mean permission to do that which otherwise would be illegal in the eyes of the public authorities. So what does that mean when we talk about a marriage license? Does that mean that in order to marry the person that I love, I need permission from the state? This is the land of the free. Now, I could sign a marriage contract with the person that I love, and that would be a common law agreement between us. And that would be a binding agreement, because that's the law of the land, it's common law. But now here the government comes along and they put this extra layer of law on top of common law called maritime law. And they say, hey, you want to marry the person you love? That's great. We're very proud of you. We're very happy for both of you. Just need to ask our permission in order to do it. Now, the government usually gives permission for people as long as they're not related to one another, right? As long as maybe they pass a certain blood test, right, to prove that they're not related to one another or something like that. Or that used to be how marriage licenses used to be issued. What happens if they put other requirements and limitations on the permission that they grant in regards to a marriage license? So that's the difference between the kinds of law. Anybody, I mean, I see that there are people who are asking questions about how to move forward with the PMA.
Yeah, Jonathan, do you want to go back to where you left off with, let's see, Kathy, and okay, so you're going, so yeah, some people are asking about just sort of the nuts and bolts of setting this up, and you had said that you can do this, and
Sure.
So it doesn't need to be through an attorney, basically, right?
Most likely is not going to be through an attorney who is a member of the Bar Association and is an officer of the public courts. There are a lot of people who are what's referred to as an attorney in fact. Remember, the right to practice law is, again, not limited to the public domain. Private law, and there are a lot of people out there who are very versed in private law, who write private membership documents. Some of them I've trained with, and they've taught me. And some of those guys used to be chief of police in Texas, and former judges and such, who no longer have their bar association membership.
So if people want to get documents to set this up, they would need to find you or someone like you who has access to these documents, or can we access these documents like online somewhere?
It's like anything else. In other words, just like being a homeopath, you can grab a book off the shelf and you can read it, and you can read another book off the shelf, and you can then hang a shingle out there, and you can start providing services to people, in regards to homeopathy. But then there's going to be a little bit of a difference in regards to the skill of the practitioner than somebody who maybe went to school for 3 years that was actually taught this by a homeopath, who had supervision in doing that. And that's kind of be the difference. I put up my email address that people can reach out to me if they have any other questions. I didn't really want to use this as a venue for me to advertise my services, but at the same time, it's hard to ignore the fact that, yes, I'm one of the people out there who is writing a lot of private membership association agreements for homeopaths and homeopathic pharmacies and dispensaries and such. So anybody who's interested in looking for a consultant to help them with this can send me an email on, that I put into the chat, and I would help you do that. What it looks like when forming a private membership association is it's a contract. It's a contract between yourself and somebody else. So it starts at a minimum with 2 people. In order to exercise your fundamental freedom of association, you have to associate with somebody. In order to sign a contract, you kind of have to sign a contract with somebody. You can't sign a contract by yourself, and it be legally binding. So we start with a contract called the Articles of Association. And this is a contract that establishes the actual association. 2 people coming together, exercising their freedom of association, their right to contract, and are agreeing with one another to form an association. And from there, we use another document typically called the Declaration of the Charter and Bylaws, in which the same people create a structure by which the association is required to operate by. These are the rules and regulations of the association. And that's going to be the second document that we use. In some circumstances, we will have a third document called a certification, and that certifies the establishment of the association to others. It names the association and names the founding trustees, and it can be used as a certification for the existence of the association. At that point in time, the association exists. It has a framework by which it's required to operate by. It can announce itself to others in regards to its existence. And then we're able to open itself up to members to join voluntarily with informed consent to become members of the association. And that's the membership agreement. So I saw that there was a question. Does that mean that everyone has to, so is basically signing a contract with you that I'm having them sign? So it is basically a contract that you're having people sign. So no different than a liability waiver, a consent to treatment document that many people use. I know that there are a lot of people who use a consent to treatment document, even when they're working through an LLC. It's very similar to that. It's a membership agreement that people are consenting to voluntarily, with knowledge of what's in the document, and they're joining the association in order to receive services. I'll give you actually an example. Thing that, there we go. So there's a link right there, and people can click on that link, and they can see what an agreement kind of looks like by applying to be a member of my association. In fact, actually, if you follow through the link, it gives you an opportunity to actually schedule a call with me to talk about forming a private membership association. And that's because I don't provide any services to anybody who is not a member of my association. So the first thing that you're going to do before booking a call with me is you're going to join my association. That's what keeps the business between us private. And that's what's important, is that there is no way that it can be claimed that I'm providing these services to members of the public. Catherine asked a question, will this protect the homeopathic pharmacies and dispensaries in the event that the FDA tries to get rid of remedies? Could they set up their business this way? So it's interesting that you asked that, because I actually work with a licensed, an FDA licensed homeopathic manufacturer that manufactures essences, not limited to the Bach essences, which are in the homeopathic pharmacopoeia of the United States. They manufacture a lot of different other types of essences, Australian bush essences, they manufacture gemstone essences. And I've been working with them for a number of years. And recently they got a little letter from the FDA asking some questions about some of the inactive ingredients on their labels. And we'll be moving forward with forming a private membership association in which the products that they manufacture will no longer be available to the public, that people will have to consent to membership in the association in order to buy the product. Now, what does it look like when you consent to an agreement? Well, it can be as simple as consenting to the terms, just like you consent to your iPhone terms of service when you update your iPhone. I've been trying to update my iPhone software for the past 3 days. They've been having a little bit of a problem, it seems, with the most recent update. So hopefully, Tim Cook and Apple will fix that. But at some point in time, I'm going to be able to update my software. And how are they going to have me agree to the newest terms of service? This 80 pages of tiny fine print. Well, I'm going to click I agree. And then a little pop-up box is going to pop up and say, by checking this box, you consent to the terms of service of iTunes or iPhone or Apple. And then you have to click I agree again. Now, I'll admit that I didn't read all 80 pages of that little fine print. I don't know if I just gave away the naming of my next child, or if I've guaranteed that I have to give them my car in case Tim Cook needs a lift when he's in town. But at the end of the day, I just want my phone to work really well, so I just click I agree to get my phone updated. So it doesn't have to be such a long, drawn out, overt contract. You'll see in my agreement that I'm making it pretty clear. I make it a little bit clearer than I used to. I used to when a year or two ago, when I would operate and take on clients through my association, it was literally just 2 check boxes that you had to check, and one of them had a hyperlink that if you clicked on it, it took you to a web page, and there was my 80 pages of fine print that you could read. These days, I actually put some of that text actually in the contract. But yeah, that's what people are consenting to in order to become members of the association.
And someone, Jonathan, someone is also asking about liability insurance. How does that work with the PMA? Is there somebody named Marty, it looks like?
Yeah, so I had mentioned this before. Technically, it's not necessary, but it's still prudent. The example I typically give is actually when I work with certain wellness centers. There are a lot of these new high-tech wellness centers that are opening up all over the world and all over the country that are using this scalar technology to provide healing, of people and such. And they ask me, and they're set up as a private membership association. I've set up a number of them. And they'll ask me, in other words, Jonathan, do I need liability insurance? And I'm saying well, technically, people are waiving liability. They're agreeing to hold harmless. They're agreeing not to commence any action against any member of the association without the association's permission in advance. So not necessary. Still prudent, though. What happens if somebody slips and falls in your center, and now all of a sudden they hurt themselves and they've got $10,000 in medical bills? Is your response to them going to be, hey, listen, sorry, but you pretty much agreed not to, to hold us harmless and to waive liability and not to commence any sort of action against us. So sorry that you got $10,000 in medical damages and medical expenses, but them's the breaks. wouldn't it be nice to have a liability insurance carrier's checkbook sitting there who's willing to sign a check because they've insured for liability in case anybody slips and falls, to go against and say, hey, listen, I need to file a claim because this person slipped and fell and hurt themselves? To me, that sounds like more what I'd be looking for. So for in that circumstance, I think it's prudent to have liability insurance, even if it's not required.
And I just want to jump in before you answer your next question, Jonathan, and just tell everyone that we'll have about 10 minutes at the end for anybody who wants to ask questions with your video on and just like actually vocally have, a dialogue.
Sure.
With Jonathan, with the recording off. So we'll record for another 8 minutes or so and go through the questions that have been typed in the chat box, and then I'll shut off the recording. Anybody who wants to stay and just ask Jonathan more questions can do so.
Great.
So see, I think you left off with, let's see here. Okay, David Shine, under what jurisdiction would challenges under this contractual structure occur?
Sure. So that's the challenge. The challenge that will occur is going to be in regards to subject matter jurisdiction. And the reason why we want the agreement to be explicit and in writing is a precautionary defense for that claim of jurisdiction. There are a lot of different ways that you can consent to an agreement. You can sign a physical contract printed on bond paper, signing it with a blue ink and a red thumbprint in front of a notary public, and that's going to be a really good way of demonstrating consent to an agreement. The worst way is probably through a verbal agreement in which there is no evidence of what's being agreed to. So having a properly formed private membership association in which you are able to actually capture consent from people and demonstrate that they've consented to this agreement, the terms of this agreement are private and outside of the public authority's jurisdiction. So by them, if a claim was made, the first response that we have is to challenge jurisdiction, because the government cannot intercede between parties of a private agreement. And that's what this is. This is a private agreement, and it has its own venue and jurisdiction clause within the agreement, that it has its own internal mandatory arbitration process by which people are contractually obligated to participate in regarding any disputes that take place as a member of the association. So that's how jurisdictional challenges really kind of play out when it comes to these things. Kathy asked the question about the 3 states in the US that require a person to be an MD before practicing homeopathy. Maureen, you remember what these were? I thought Arizona was one of them, actually, or Nevada, maybe.
I think Minnesota is one. Minnesota and Arizona for sure, but I can't remember the other one.
Minnesota, right? Let's see. Arizona, Connecticut, and Nevada. In those states, homeopaths must, I think, be a licensed healthcare professional. I thought there was one near me. I thought it was Connecticut, actually. So Arizona, Connecticut, and Nevada require licensing for homeopathic practitioners. Having a PMA has different tax obligations than an LLC or an LOC. Yes, it's a little bit more of an esoteric question if you think about it, because taxes are frankly, taxes in the United States are voluntary in regards to income taxes, as opposed to alcohol taxes, which in the United States are deemed mandatory, at least by the IRS. So, and there's a question about the tax obligations, is that this is a much deeper dive, and there are different tax obligations depending upon how a private membership association is formed. let's see, can you talk about getting an EIN as a PMA for banking purposes? Sure. So private membership associations can obtain EINs for banking purposes. Again, it depends upon how the association is established. It's something that I do, considering that the private membership association is outside of U.S. jurisdiction. In other words, it's not written in a statutory language. It's not within the public authority's jurisdiction. It is considered foreign to the public authorities. So as a foreign entity, it obtains a foreign EIN, and it's able to do so for banking purposes. And that requires the filing of what's known as an SS4 document in order to obtain an EIN, because all organizations in regards to banking require some sort of identification number in order to open up an account at a bank. So all banks are licensed by the public authorities, so they require an EIN number or either a social security number or a passport number in order to open up an account. So that's something that also, when working with clients, I help walk them through the process of obtaining an EIN for their bank account. I think there was also a question about somebody who got their bachelor's in homeopathy from India and wanted to continue their career in homeopathy in the United States. That's definitely something that you can do. If I'm not mistaken, CHC allows for graduates of overseas diplomas to apply as an overseas. Maybe Chital can answer this better than I can, but I've seen that overseas graduates are able to obtain certification, and I would recommend that that you would maybe explore certification as a graduate from a homeopathic program in India, because without real licensing in this country, board certification is really the place where we're able to demonstrate our professionalism, because our colleagues essentially agree that we meet the standards necessary to be a professional homeopath by passing the board exam and becoming board certified. So that is definitely something that I would recommend. What about having an international practice online? It's definitely something that you can do. I mean, many of us obviously are already working online, and working with people all over the world. When it comes to the services that you're providing, who is your client? Who is your patient? Is it a member of the public? If it's a member of the public authorities are going to be there to regulate that relationship, because that's their job. They take tacit consent, basically, by the sheer fact that you're alive and you're out there and acting and operating with members of the public. Therefore, they take it under their responsibility to protect members of the public. So in that case, there's going to be limitations on what you can do. If you're not providing a service to the public, but instead providing a service to people who are private members who have a private contractual relationship with you to provide those services, then they're not going to be able to regulate that. And then Kathy asked if you have an EIN already, can you transfer it to a PMA? No, you can't. A PMA is a separate entity that is legally separate and distinct. So any EIN that you had for any sort of other entity would be specific to that entity. And if you then wanted to operate as a PMA, you would need a new EIN. Not difficult, takes about, just takes a couple of days to get. That EIN would be specific to that organization, that new entity that was being formed.
Jonathan, I'm going to go ahead and stop the recording, and then anyone who has additional questions can go ahead and ask. Feel free to stay and ask. This is really interesting. Thank you very much for this info. It's really, it's not readily available. So we really appreciate you being here.